Today's case takes a wild turn right from the start. We're in a Tennessee courtroom, and the judge is about to face something that feels more like a legal comedy than a hearing. The defendant? Matthew Aldridge. The problem? The man standing up claims he's not Matthew Aldridge. He's his attorney, in fact. What does that even mean? Well, as we'll see, this courtroom moment spirals into a showdown between actual law and what's known as the sovereign citizen ideology, where defendants try to outsmart the system by claiming the law doesn't apply to them. But this judge, he's not buying it for a second. Stick around. This gets intense, confusing, and kind of hilarious all at once.
All right, good morning. We're going to go through the docket as quickly as we can so that we can start on the jail docket. 2021 CR 19158, State versus Matthew Aldridge. Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
His authorization.
Notice how the judge is immediately skeptical. Attorney of fact? That's not a legally recognized role in criminal court. In Tennessee, as in every U.S. state, only licensed attorneys can represent another person in a criminal case. So, right off the bat, this man's argument is on thin ice. The judge is trying to figure out if this person is confused, delusional, or deliberately trying to manipulate the system.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent area.
Well, let me explain to you.
The judge gives him a fair chance here, asking if he has a power of attorney document, which is the only legal way to act on someone's behalf. When the man admits he doesn't have one, the judge makes it crystal clear. You have no authority to speak for Matthew Aldridge. That's a legal dead end. It's like showing up in court and claiming to be someone's doctor without a medical license. It's not just wrong, it's potentially criminal.
Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not at this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't the court just let me file this document?
Show it to the bailiff and he'll show it to me. Apparently there's a copy here.
Yeah.
All right. This is in the state of Tennessee.
And now, the courtroom takes a sharp turn into pseudo-legal fantasy land. The man starts reading out documents full of legal jargon, old Latin phrases, and random case citations. All classic signs of sovereign citizen filings. These are documents that look legal, but in reality have no standing whatsoever. Judges across the U.S. see these all the time, and they're instantly recognized as meaningless paperwork.
In the state of Tennessee, of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
Here's where the judge finally calls it out. He recognizes this for what it is, a sovereign citizen tactic. These arguments usually claim the court has no jurisdiction over living men or that the state is a corporation. But that's not how law works. The judge remains composed but firm, reminding everyone that this isn't civil litigation. It's criminal court, and no amount of legal mumbo-jumbo can erase that.
That's the respondent in error signature.
All right. Well, I find that Matthew Neal Aldridge has failed to appear personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neal Aldridge. If you are, in fact, Matthew Neal Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm
Now, pay attention to this part. The judge drops a constitutional mic. He references both the U.S. and Tennessee constitutions, making it clear this court has authority under law by the people to prosecute criminal cases. It's a subtle but powerful reminder that no amount of pseudo-legal argument can override the real justice system.
That is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
The defendant, or whoever he is, tries to pivot, asking if this will be an Article 3 trial. That's another sovereign buzzword. They love to reference the U.S. Constitution to claim jurisdictional loopholes, but the judge just confirms it plainly. Yes, it'll be a trial by jury. You can almost hear the exhaustion in his voice. He's dealing with someone who's not here for justice, but to perform a legal stunt.
Is that an Article 3 trial?
To what?
Will that be an Article 3 trial? A trial by jury with jury?
It would be a trial by jury. Certainly, it would be. But I don't know who you are.
And here comes the judge's frustration. He tells the man he's wasting everyone's time, including other citizens waiting for their cases. Imagine being in that courtroom, watching this unfold while your own hearing is delayed because someone refuses to even confirm their identity. The patience this judge shows is impressive. Most would have held the man in contempt by now.
And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are, in fact, Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately, it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial
The
date.
judge decides to push forward despite the chaos. Since the real Matthew Aldridge didn't appear in person, the court resets his trial for July 15th. But make no mistake, this is not a favor. It's a final warning. The judge is signaling that the court won't play along with any more identity games or fictional legal roles.
A new trial date for Matthew Lynn Aldridge. Now, is there a possible the jury warrants? You put a notice up there for tonight, if we don't need you tomorrow, but we need you on February the Is that possible? General, we're going to need to set a trial date in July.
July 15th.
I'm sorry,
July 15th.
July 15th.
At this point, the judge officially denies the so-called motion filed by the man, calling it what it is, invalid. He points out that the filing cites no criminal statute, meaning it's completely irrelevant. Judges rarely use strong language, but here, even his tone says, enough is enough. It's one of those moments where the courtroom regains control after a long stretch of nonsense.
But to Matthew Aldridge and the individual standing before me, whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th, the last day for Mr.
This summary from the clerk is key. The man who appeared had no legal authority to represent anyone. His filings were rejected, and the court reaffirmed the July 15th trial date. The message is simple. The justice system runs on law, not fantasy. Whether someone believes in sovereign theories or not, they still have to follow the same rules as everyone else.
Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are, in fact, Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.